court has reviewed the statute as well as State versus Amison, which is a 12th District Court of Appeals case, 2021 Ohio 1537. And in that case, the trial court declined to give an instruction on voluntary manslaughter in a murder case, and the 12th District Court of Appeals upheld the trial court's decision. The court referenced State versus Gray, also out of the 12th District, 2011 Ohio 666 in its decision, and indicated that for provocation to be sufficient, it must be sufficient to arouse the passions of an ordinary person beyond the power of his or her control. And I quote from the Gray case that was referenced in Amison: if insufficient evidence of provocation is presented so that no reasonable jury would decide that an actor was reasonably provoked by the victim, the trial judge must, as a matter of law, refuse to give a voluntary manslaughter instruction. And the court has carefully reviewed the evidence that the defendant believes was proffered that would support the instruction. However, in this court's mind, the court does not believe there is sufficient evidence for it to give the voluntary manslaughter instruction, so it is respectfully going to deny that request. Anything else with the jury instructions that we have gone over to the court proposed previously?
I think all of them are standard issued OJI instructions. I would just ask for a new copy of what it is. It's also can be read to the jury.
Okay. Any other requests or additions, Mr. Wilder?
Other than what we requested, I understand the court's ruling. I didn't have any other issue with the instructions as given to me.
Okay. All right. I'm going to use the same copy that I gave to you, but we will be printing them out for the jurors. If we make corrections during the course of that, I'll print up a new copy and make sure everybody has those before they go back to the jury.
I do, somewhere. Your Honor, when I read through the draft, I think the pronouns were wrong in some of the parts. I think it said her, it should say him. Okay,
I will hopefully catch those as I read them and make the changes for the final copy that I'll provide to you and before it goes back to the jury.
Judge, if I
yes,
may, I did note that Mr. Madden's decision, he just put on the record to not testify. Obviously, the language of him not testifying needs to be in the instruction.
That is correct.
Oh, because he had it in that he
would.
would.
It says
Yes,
does
sir.
testify, so obviously there needs to be language about him not testifying and accept the standard language of not used evidence. So.
All right. Thank you for that.
Your Honor, if I could just add one more thing. I've asked him multiple times to paint us some information that would show how this all started, and he's refused over a period of months. He's told me to my face that he's not going to subpoena the information, and that if I try, he said later on, you're just going to have to file an appeal. But I'm not, for the same reason that the neighbor that was next door to us, the mayor, the one who robbed the bank, there was on record, that she was saying that me and Rachelle both were great neighbors, and I don't look like somebody that would be a murderer. And, she was happy to have us, and she let me use the phone all these different times to call while we still were living. But he thought that wasn't sufficient enough evidence for the jury to hear, and I thought it was. He said, but if you try to bring that forth, I'm going to make sure that she shuts it down. Why would he have you shut that down? I don't understand, but listen, you've made a ruling. There's plenty of things that I thought that needed to come out. For example, when I asked him to ask the detective, this gentleman right here, when he ran down the hallway after I was beat up on March the 27th and taken down 2 hallways, dragged out of my shoes down to the bottom of the basement inside a cell. You could hear me screaming out. Why did he leave this courtroom and run down 2 hallways? Why did he come up to my face? What did he say to me? What? He goes, I don't. And then, when I said, hey, ask him if he knows Rachelle's niece who works at the front desk at the Hamilton Police Department in the same building that he works at. I just asked him if he knows how well he knows her. He refused to do that. So there's so many things that I thought that I I just wanted to put on the record,
Right.
and that's all I have to say right now.
Is there anything else, Mr. Wilder?
Judge, I'm not going to respond to the allegations because if I were to do that, I would be breaking attorney-client privilege, and I'm not going to do that at this point. I'm prepared to argue his case as best I can based on the limited discussion we've had about the case. Despite my many efforts and meetings with him, not having a lot of information about the situation that occurred has limited me, but I'll just leave it at that.
Well, one other thing. You know that on March the 27th, about near 9 a.m. 2024, I was brought in here in the afternoon, probably sometime. Most of the time I had hearings that were in the afternoon, 3:15, 1:45, times that my family didn't even know that because times were being logged on the computer when I was having court. So nobody could be here. I was brought up with no other inmates. I was always and woken up out of my sleep saying, hey, you got a court date today. Having hearings without me there. But I was in the jury box and I said, hey, they wanted to have a proceeding with me while I was inside there. And I said, I protested. I said, hey, listen, I'd like to be at the desk, so that I can go on record. Because if at any time that there's been a proceeding or a hearing here, if you haven't heard my voice, then you can sure be 100% know for a fact that I wasn't there. And being that I was not allowed to come over and sit at the desk, listen, and I protested. I didn't want him as an attorney. You know that I didn't want him as an attorney. And I told you all that. I don't want him as an attorney. And for that reason, it said get him. And I had his shoes beaten off of me all the way down the hallway, down 2 hallways, down to the elevator. And this man right here gets up for some reason and comes down the hallway.
I'm going to stop you, Mr. Madden.
And ask him what he said to him.
We've talked about some of this before. Okay. Your jury is waiting, and I don't want to keep them waiting, okay?
Yes, ma'am.
So if everybody's prepared to go forward, we'll go on with the closing arguments, and I'll have the jury instructions modified while we're doing that and have them passed out to you before they're read to the jurors. But we will change the language of that.
On the record, I did ask for that preservation of that footage. Of the footage when I was beat up at the jail too. So, but none of those things. Multiple times. But here we are.
And we're going to go ahead and bring in the jurors. Okay. Thank you. Ladies and gentlemen, does anyone have any violations of the court's recess instructions to report? Okay. All right. We left off with the last witness being presented by the state of Ohio. How does the state of Ohio wish to proceed this morning?
Yes, Your Honor, at this point, with the admission of all the state's exhibits, the state has no other witnesses to present to the ladies and gentlemen of the jury, and the state will rest.
Very well. And Mr. Wilder, does the defendant wish to present a case?
No, Your Honor. Thank you.
Very well. Okay. Okay, so ladies and gentlemen, you have now heard all of the witnesses, and you will receive all of the exhibits into evidence, and it's time for closing arguments. So please keep in mind that the closing arguments are not evidence. They are designed to assist you, and they are the attorney's views of how they think the evidence proves or does not prove the charges. So they are designed to assist you, but they are not evidence. Now, in accordance with the rules, because the state of Ohio has the burden of proof, the prosecution will go first with its closing argument, and after they have concluded, the defense will have the opportunity to present its closing argument, and then because of that burden of proof, the prosecution has the burden to give you final words in a rebuttal closing argument. So that is how we will proceed with this portion of the trial, and whenever the state is prepared to go forward, you may do so.